Hello, I'm attorney Todd Leneve. Welcome to West Virginia Gun Law. Over the weekend, there was an important development in the case involving interpretation and application of the ATF's final rule on private sales and what it means to be engaged in the business. I wanted to take a few minutes here with you today and break that down. Stick around. Yesterday, May 19th, 2024, U.S. District Court Judge Matthew Kaczmarek entered an order granting a temporary injunction against enforcement of the ATF's final rule on private sales. Now, unfortunately, this was not an injunction that applies nationwide, but rather applies only to the named plaintiffs in the case. And so what that means is that most of you watching probably are not covered by the protection of the judge's order, but there is a decent chance that some of you, in fact, are. The people who are expressly covered, or the organizations that are expressly covered by the case, are the individual named plaintiff, Jeffrey Tormey, residents of the state of Texas, and then the other organizations that are shown here on the screen. So if you happen to be a member of any of these organizations, you also are covered under the protection of the judge's order. Now, I want to take just a second here to emphasize the importance of supporting your grassroots, locally and nationally, 2A organizations, because those are the ones that are actively getting involved in litigation around the country, fighting against unconstitutional and unlawful actions by the government like these that impact our Second Amendment rights. So I've got a list down in the description below of 3 of the primary organizations that are involved in ongoing litigation around the country. And I would encourage you, join one or all of them so that, 1, you're providing support to organizations that are doing good work and important work on our behalf, but 2, that you're also covered when they get rulings like this in which an injunction applies to members of that organization. So as a result of the hearing that the judge held on Friday, May 17th, 2024, his ruling indicates that he finds that there are at least 3 ways that the ATF's final rule conflicts directly with the language of the Bipartisan Safer Communities Act, which is the, of course, sweeping federal legislation that imposed changes to Second Amendment rights and protections, and is the basis on which the ATF is issuing this final rule. So let's do a quick breakdown of those areas that the judge identified and give you at least a little better insight and understanding into what his thinking was as he approached the issues presented in this case. First, the rule says there is no minimum number of firearm sales that is necessary to require licensing, and that even a single transaction or offer to sell may be enough. But the Act says the term engaged in the business shall not include a person who makes occasional sales, exchanges, or purchases of firearms for the enhancement of a personal collection or for a hobby, or who sells all or part of his personal collection of firearms. In this aspect of his opinion, the judge is saying that the language of the rule says that a single transaction may be enough to trigger enforcement under the language of that rule, whereas the law, which actually applies here and which the rule is supposed to interpret, does not support the idea that a single transaction is enough, but rather uses plural terms and speaks about multiple occasions on which an individual may choose to sell a firearm. Second, the rule states actual profit is not a requirement of the statute. It is only the predominant intent to earn a profit through the repetitive purchase and resale of firearms that is required. In other words, a person may repeatedly advertise and display firearms for sale and therefore demonstrate a predominant intent to earn a profit from repeatedly reselling the firearms purchased, but never actually find a buyer. However, the Act says the term to predominantly earn a profit means that the intent underlying the sale or disposition of firearms is predominantly one of obtaining pecuniary gain, as opposed to other intents, such as improving or liquidating a personal firearms collection. What the judge is saying here is that, first off, the ATF claims in its rule that any act in which you advertise firearms for sale indicates that you may be intending to make a profit, and doing so repeatedly indicates an intent to make a profit or have pecuniary gain. However, the judge says that the law, as opposed to the rule, is different in that it does in fact allow private individuals to sell firearms more than once, and that they are allowed to make a profit, provided that they're doing so for the purpose of enhancing or improving a personal collection or just liquidating that collection. So what's that mean? Essentially, the judge is saying if you sell a firearm, you make a profit, and your intent was to make a profit so that you could turn around and buy perhaps a more desirable gun to add to your collection, that's okay, because the law does not suggest that that type of activity is outside the bounds of the law, but rather seems to be protected. Third, the judge found that the rule arbitrarily eviscerates 18 U.S.C. section 921A21C's safe harbor provision, which protects individuals who make occasional sales, exchanges, or purchases of firearms for the enhancement of a personal collection or for a hobby, or who sells all or part of his personal collection. This portion is particularly important to firearms owners because the judge addresses in his opinion the fact that the ATF rule expressly excludes firearms designed for defensive use or purposes. The ruling states, nothing in the foregoing text suggests that the term personal collection does not include firearms accumulated primarily for personal protection. Yet that is exactly what the final rule asserts. In his opinion, the judge goes on to explain that statistically, about 2/3 of the firearms sold and owned in the United States are firearms that are designed with the intent of personal protection in mind. And so his position is that saying that such firearms are not part of a personal collection or don't fall under the definition of a personal collection is clearly off the mark. And again, frankly, it's not covered like that under the law. Therefore, the rule saying that personal defensive firearms are not part of a personal private collection is clearly contradictory. And again, where there's a contradiction, the language of the law applies and the language of the rule is going to be set aside. So the final point that the judge raises, and I think this is one of the best things in the entire opinion, is that there are various legal presumptions that the ATF's final rule puts into place, essentially saying that if I turn around and sell a firearm, that it's going to be presumed that I was doing so for profit or for pecuniary gain, and therefore my act is illegal. However, the rule says I have the right as a private individual against whom the rule is sought to be enforced to rebut that presumption, or in other words, try to disprove that that presumption applies to me. To say, hey, I wasn't selling for a profit. I had a legitimate legal motive for selling this firearm. I don't need to buy a federal firearms license and go through that whole process. So in addressing that point about these presumptions, which are a huge issue to be of concern for the average person, the judge put a literal smackdown on the ATF and slapped them upside the head with this little gem. Plaintiffs understandably fear that these presumptions will trigger civil or criminal penalties for conduct deemed lawful just yesterday. Nevertheless, ATF avers that its knowledge of existing case law and subject matter expertise will prevent misuse or abuse of the presumptions. In other words, just trust us. So clearly, Judge Kaczmarek gets it like the rest of us do. He understands that there is a widespread distrust of the ATF and its motivation. So essentially here, what has gone on is the judge has made the legal findings necessary to be permitted to grant a temporary injunction. That is good news for us because it means that this judge has it in his mind that the ATF is off the mark on this rule and that they have violated the practices that are to be followed under the Administrative Procedures Act prior to imposing a rule like this. So this is one that, again, we're going to have to stay tuned to, keep an eye on it. Until there's been a final disposition at the trial court level with Judge Kaczmarek, whether it's a trial or whether it's some pretrial resolution, those of us who are not covered by the protection of this injunction need to understand that we must live under the terms of this new rule, and we've got to be cautious about any kind of firearms transactions that may take place. But the great news out of all this is that even if we would make a sale and somehow get onto the radar of the ATF, find ourselves in legal trouble, this opinion is a pretty good indicator that the law would be on our side in defending against any kind of a claim by the government seeking to enforce penalties of some sort, whether civil or criminal, against us for having sold a firearm. Now, obviously, it's going to differ from jurisdiction to jurisdiction, and the blue state versus red state judge's argument is a real thing, and it's something you need to be aware of. So again, we need to keep a close eye on this case and watch how it progresses. And in the end, we need to wait until there's been a final disposition, and frankly, probably the appeals have all run their course before we're going to know the ultimate fate of the ATF's final rule here. Listen, I know this is a fairly in-depth subject. If you have questions on it, you know how to get in touch with us through the information. The website's linked down below in the description. Please reach out, let me know. You can also leave questions or comments in the comments section. Would really appreciate you doing that. If you haven't subscribed yet to the channel, please do so. Hit that like button, share this video, because this is something that's going to affect a huge portion of the Second Amendment community, and a lot of people may not be aware of the status of this case. So I would really appreciate you doing your part to help us all out as a community, be better served, and be better informed. I appreciate you spending the time with me today, and I look forward to seeing you in the next video. Until then, take care and be safe.